So very good evening all the participants. So Himanshu Malik ji, you are ready? We can start from section number 4.
Yes,
So please share.
sir. Just the voice is breaking for all the for me only.
Oh, it's breaking. Sound is breaking.
It's breaking, sir. Yes.
नहीं मेरी वॉइस ब्रेक हो रही है क्या?
Oh, sir, your voice is okay, sir. Madam
Okay.
voice it is breaking.
अच्छा, क्या हिमांशु जी की वॉइस ब्रेक हो रही है ऐसा बोल रहे हैं?
यस सर।
ओके ओके ओके, कोई बात नहीं, मैं शेयर करता हूँ. लेट मी शेयर इट. So I hope my screen is visible. Is it visible?
यस सर।
Okay. So section 4. What section 4 says? Section 4 talks of applicability. So it says, because section 4 is in part 2. So it says application of this part. This part shall apply to matters relating to insolvency and liquidation of corporate debtors where the minimum amount of default is 1 lakh rupees. Provided that the central government may by notification specify the minimum amount of default of higher value which shall not be more than 1 crore rupees. And the central government issued a notification enhancing it to 1 crore rupees. Provided further that the central government may by notification specify such minimum amount of default of higher value which shall not be more than 1 crore rupees for matters relating to pre-packaged insolvency resolution process of corporate debtors. And the central government issued a notification. They said that the minimum amount of default for pre-pack process will be 10 lakh rupees. Now, lot of questions came in section 4 because let us go to the jurisprudence on this. Just a minute. September. Let me share with you. So this is section wise jurisprudence. So before we go to section 5, let us see the issues in section number 4. So what were the issues involved? The first point was because the notification was issued, so whether it is prospective or retrospective. That was the first question which came. Section number 4. Just a minute. थोड़ा सा बड़ा कर देता हूँ. I think now it is clear. है ना? Visible है ना?
यस सर। यस सर।
So here, because the notification was issued on 24th of March due to the onset of epidemic, this COVID period. So it says the announcement of threshold by notification dated 24th March 2020 issued by the Ministry of Corporate Affairs is prospective in nature and would not apply to the pending applications filed prior to the issuance of the said notification. So they said it would not apply to pending applications. Suppose an application has already been filed. So the question was whether this enhancement limit will be applicable to those applications also which have already been filed. The answer is no.
No.
This is first. Now second point. Here they say the notification dated 24th March issued by the Ministry of Corporate Affairs, whereby the minimum amount of default was specified as 1 crore is prospective in nature and not a retrospective. Next question, next law was that the law is very clear that it is enough if under section 4 of the code the unpaid debt is more than the threshold value of 1 lakh for acceptance of application under section 9 of the code. So because it was an earlier case, so they said that if the unpaid debt is more than the threshold value, which was subsequently raised to 1 crore, so they say the unpaid debt should be more than the threshold value. This is the takeaway from this case. Next was where the default has occurred prior to the issuance of notification. Now let us take a case that default has occurred prior to 24th March 2020. Demand notice was also delivered prior to that notification, but application was filed after 24th March. So in this case, whether the enhancement limit will be applicable or not. So they said in such a case where default has occurred prior to 24th March, demand notice was also delivered prior to that notification, but application has been filed after 24th March. The enhancement of the threshold limit from 1 lakh to 1 crore is not applicable.
So can you please explain the previous one? The law is very clear. It is enough. Under
Actually,
section.
yes. So they say we should not confuse it with 1 lakh. Basically, because the only takeaway from this case is if the unpaid debt is more than the threshold value. Earlier it was 1 lakh.
Okay.
Now it was made 1
Okay.
crore. So they said if the unpaid debt is more than the threshold value, so then it is enough for acceptance of the application.
Okay.
Next point was that the interest amount cannot be clubbed with the principal amount of debt to arrive at the minimum threshold of 1 crore for complying with the provisions of section 4 of the code for an application filed under section 9. Actually, in case of financial debt only, the interest is to be considered. But in case of operational debt, only the principal amount has to be considered. So this is the distinction. So they say for the purpose of filing an application under section 9, the interest amount cannot be clubbed with the principal amount. That is the takeaway from this case. In Thakran Web Innovations, they said that from the date of the amendment, Part 2 of the code can apply only to matters relating to insolvency and liquidation of CD, where the minimum amount of default is 1 crore. The application of Part 2 itself is taken away with effect from 24th March as far as the default less than 1 crore are concerned. And as no application can be filed after 24th March regarding an amount where the default is less than 1 crore rupees. So, a few takeaways from this case, from these case laws were: number one, that the amendment is prospective in nature. Second, there could have been cases where application has already been filed or default has already occurred and demand notice has also been served. So in those cases also, the original limit of 1 lakh will apply. But in normal circumstances, the limit of 1 crore will be applicable. Now let us go to section 5. What section 5 says? Section 5 also contains various definitions. So first definition is of the adjudicating authority. I hope now it is more clear. So it
Yes.
says in this part, the adjudicating authority for the purpose of this part means the NCLT constituted under section 408 of the Companies Act. Auditor means a chartered accountant certified to practice as such by ICI under section 6 of the Chartered Accountants Act. Base resolution plan. This base resolution plan is a concept which is applicable in case of pre-pack insolvency resolution process. So in case of pre-pack, they say because it is applicable only for corporate MSMEs, so the corporate MSME itself can put up a base resolution plan. So this is base resolution plan means a resolution plan provided by the corporate data under clause C of subsection 4 of section 54A, which talks of PPIR. Chapter means a chapter under this part. Constitutional document in relation to a corporate person includes articles of association, memorandum of association of a company, and incorporation document of a LLP. Memorandum of association, articles of association, we all understand. But what could be the incorporation document of LLP? It could be the LLP agreement in most of the cases. Corporate applicant. There are three terms actually. One is corporate person. So corporate person means company or LLP or any other body corporate. Corporate debtor means a person who owes a debt. Company who owes a debt. And then corporate applicant. So corporate applicant means a corporate debtor or a member or partner of the corporate debtor who is authorized to make an application for the corporate insolvency resolution process or pre-pack as the case may be under the constitutional document of the corporate debtor. An individual who is in charge of managing the operations and resources of the corporate debtor or a person who has the control and supervision over the financial affairs of the corporate debtor. So basically, corporate applicant is a wider term and corporate applicant includes not only the corporate debtor but the CEO, CFO, etc. of the corporate debtor. Then corporate guarantor. Corporate guarantor means a corporate person who is the surety in a contract of guarantee to a corporate debtor. Now what is the meaning? So corporate guarantor means a corporate person who is the surety in a contract of guarantee to a corporate debtor. A company has taken a loan. Another company has stood as guarantor. So that is the concept of corporate guarantor. So guarantor may be an individual, guarantor may be a corporate person also. In case it is a corporate person, then the concept is of corporate guarantor. But in one case law, a peculiar situation arose where the principal debtor was a non-corporate person, but the guarantor was a corporate person. The person who took the loan, he was not a corporate person, he was a proprietor, but the guarantee was given by a corporate person. So in that case, question arose whether CIRP can be initiated against the corporate guarantor, and the answer was yes. It is given in this section-wise jurisprudence also, which says this section 5, subsection 5A, corporate guarantor. It says if CIRP has been initiated against the CD, the insolvency and bankruptcy process against the personal guarantor can be filed under section 60 subsection 2 before the same NCLT and not before the DR. Then in another case it says without initiating CIRP against the principal borrower, it is open to the FC to initiate CIRP under section 7 against the corporate guarantors, as the creditor is also the FC qua corporate guarantor. Because they say the liability of the guarantor is coextensive with that of the borrower. In another case, they said the principal debtor is discharged under the code not on the instance of a creditor but due to operation of law. That is approval of the resolution plan. Hence, the guarantor is not discharged of its liability merely because the creditor consented to a resolution plan of the principal debtor. So, even if the resolution plan is approved, still the guarantor is not absolved of its liability. So, guarantor can still be proceeded against. In another case, it was held that the corporate guarantees given by the CD can be invoked only in the event of a default on the part of the borrower. So if there is no default, then there cannot be any invocation of guarantee. In another case, it was held that it makes no difference as to whether the corporate person stood as guarantor to an individual or a corporate person. And so long as the obligation in respect of a claim is due from a corporate person falling within the definition of financial debt, then it is obvious that the creditor can proceed under section 7 of the code against such corporate person. So I think now we can again go to the definitions part. Another very important definition is of dispute. So what it says, dispute includes a suit or arbitration proceedings. So it is an inclusive definition. In the BLRC report, this dispute was a conclusive definition. So they said dispute means, but when this IBC was enacted, so they changed it to inclusive definition and they said dispute includes a suit or arbitration proceedings. So when the word includes is used, it means there could be a case where there is no suit, where there is no arbitration proceeding, but still dispute is there. And it could be relating to the existence of the amount of debt. Suppose one party is saying that I have to recover this money, but the second party says that there is no money due. So it could be even the existence of the amount of debt could be questioned. Second is regarding the quality of goods or services or the breach of a representation or warranty. Now regarding dispute, let us see some of the case laws also. So what they say on dispute. Dispute. It says any observations with regard to individual officer if made by a court of law or in any communication made by the operational creditor, the same cannot be treated to be an existence of dispute. So they say if any observations are made, right, by a court of law or in any communication made by the operational creditor, then the same cannot be treated as existence of a dispute. In Mobilox Innovations, which is in our syllabus also, so they say the test of existence of dispute is, first of all, whether the corporate debtor has raised a plausible contention requiring further investigation, which is not a patently feeble legal argument. Because sometimes just for the sake of argument, they say that there is a dispute. But Supreme Court held in this case that it should not be a patently feeble argument or an assertion of fact unsupported by evidence. Whether the defense is not spurious, mere bluster, plainly frivolous or vexatious, a dispute, if it truly exists in fact between the parties, which may or may not ultimately succeed. So they say we are not disputing here the quality of the dispute. It may or may not ultimately succeed, but there should be a plausible contention requiring further investigation. And it should not be merely a patently feeble argument or an assertion of facts unsupported by evidence. So to that extent only, the adjudicating authority is to apply its mind. Okay. Then the dispute should not be a mere eyewash, an attempt to derail the OC's entitlement to initiate the proceedings under Section 8, because they say that you cannot that an operational creditor, because IBC is not a recovery mechanism. So they say in case there is a dispute, then the operational creditor cannot file the application. Now naturally there will be a tendency to raise the dispute on frivolous grounds. So the adjudicating authority, the Supreme Court even has held that the grounds should not be frivolous. There should be a plausible contention. It should not be a mere eyewash, an attempt to derail the OC's entitlement to initiate the proceedings under Section 8 and 9 of the Code. Next is a unilateral transfer of liability. Sometimes what happens is that you transfer the liability by way of book entry from one company to another. So a unilateral transfer of liability does not constitute a dispute within the meaning of section 5 subsection 6, and an intrastate dispute between two groups of shareholders of the CD does not constitute a dispute in reference to OCs. The dispute under section 5 subsection 6 of the code must be between the CD and the OCs. On the existence of a dispute, it was observed that section 5 subsection 6 is an inclusive provision and does not confine the A from considering the existence of a dispute from a broader angle. Therefore, dispute in terms of section 8(2)(a) of the code shall not be limited to instances specified in the definition under section 5 subsection 6. So they say that in section 5 subsection 6, certain grounds have been given. But dispute could exist even on the grounds which are not specified in section 5 subsection 6. Now section 5 subsection 7, financial creditor. So financial creditor means any person to whom a financial debt is owed and includes a person to whom such debt has been legally assigned or transferred to. So they say in case of assignment of a debt, the assignee is also a financial creditor. Financial debt means a debt along with interest, if any. So there could be a case where the financial debt has been given without interest, because the words if any have been used. Suppose a holding company has given loan to the subsidiary company. It may not charge interest. So financial debt means a debt along with interest, if any, which is disbursed against the consideration for the time value of money. This is very important, that it is disbursed against the consideration for the time value of money. So demand loans will not be covered and includes money borrowed against the payment of interest, any amount raised by acceptance under any acceptance credit facility or its dematerialized equivalent. So there could be various ways of raising financial debt. It could be direct borrowing against payment of interest. It could be some acceptance credit facility. It could be some note purchase facility. It could be leasing or hire purchase liability. It could be discounting of bills. It could be forward sale or purchase agreement having commercial effect of borrowing. And they say home buyers are also included under the definition of financial debt. It could be by way of any derivative transaction, any counter indemnity obligation, any guarantee or indemnity. So these could be the various ways of financial debt. Now financial position. Now let us side by side see any jurisprudence on this financial debt, what it says. On section 5 subsection 7 regarding financial creditor, they say mere invocation of pledge of shares will not result in automatic conversion of debt into equity and repayment of debt. So if there is a pledge of shares and that pledge is invoked, so it says it will not result in automatic conversion of debt into equity and repayment of debt. Assignee of the debt is also entitled to file application, and such assignee steps into the shoes of the assignee, FC. The grouping of FC is in accordance with the amount of security holding is not discriminatory. Essential criteria for being an FC is a person to whom a financial debt is owed and includes a person to whom such debt has been legally assigned or transferred to. The debt along with interest, if any, is disbursed against the consideration for time value of money and includes any one or more mode of disbursed as mentioned in clause A to I of subsection 8 of section 5. Allottees or home buyers, they were included in the main proviso. When this IBC came, there was a lot of confusion regarding home buyers because they were neither considered financial creditors nor operational creditors. Then Supreme Court held that these home buyers are to be considered as financial creditors. So they say the allottees or home buyers were included in the main provision, that is section 58F, with effect from the inception of the code. Explanation was added in 2018 merely to clarify doubts that had arisen. The deeming fiction that is used by the explanation is to put beyond doubt the fact that the allottees are to be regarded as financial creditors within section 58F. ठीक है. In Chitra Sharma and others, it was held that home buyers are brought within the purview of the financial creditors. ठीक है. In a recurring investment plan, wherein the CD failed in its commitment to offer the allotment of plots of land as promised by it, or paid the assured returns, or repay the sums collected by it along with interest on the maturity of the schemes, the investor's position is that of a FC, as per section 5 subsection 7, read with section 5 subsection 8 of the code. Sometimes what happens is that you might have seen the advertisements in paper regarding assured returns. Okay. So they say in a recurring investment plan wherein the CD failed in its commitment to offer the allotment of plots of land as promised by it, or pay the assured returns, or repay the sums collected by it. Sometimes the builders collect the money. Now what they offer? They say that okay, we will pay you a assured return. Second is they may offer them plots of land, or they will say that if we are not able to give either, then we will repay. So it will come under the definition of financial debt. In this case of Phoenix ARC Private Limited, the Supreme Court reiterated that a person having only security interest over the assets of the CD, even if falling within the description of secured creditor, by virtue of collateral security extended by the CD, would not be covered by the definition of financial creditor under the code. So if a person is simply having the security interest, even if it is falling with the definition of secured creditor, by virtue of collateral security extended by the CD, it would not be covered by the definition of financial creditor. It held that the CD in the matter has only extended security through pledge of shares, and there was no liability to repay the loan taken by the borrower on the CD. Therefore, the creditor in such a case will at best be secured creditor qua CD and not the financial creditor qua CD. Now, banks or financial institutions which have advanced loans to the home buyers, they cannot be considered as FCs and included in COC, specifically in the light of the fact that the liability to repay the home loan is on the individual home buyers. You might have witnessed cases where the people take loan from the banks and financial institutions. So the question is, suppose a CD is a builder. Now people have applied for flats. Suppose Mr. Ramlal has applied for a flat in a scheme proposed by the builder and he has taken loan from the bank. Now the question is, the bank which has advanced loan to that home buyer, Mr. Ramlal, whether he can be included in the definition of financial creditor. The answer is no. Because the primary liability is of the individual home. Section 5 subsection 8, financial debt. At times you might have seen the joint development agreements. So what it says? In case of joint development agreements, land is owned by one party and superstructure is being constructed by the other party. Development is done by the other party and they combine together. They may agree on sharing of profits, etc. So here they say that the joint development agreement entered is a contract of reciprocal rights and obligations. Both parties are admittedly joint development partners who entered into a consortium of sorts for developing an integrated township. And for any breach of terms of contract, Section 7 application is not maintainable. Suppose there is a dispute between the landowner and the developer. Both entered into an agreement that they will develop a piece of land and then they will share the proceeds. So they say if there is any breach of any term, then Section 7 application is not maintainable as the amount cannot be construed as financial debt. Similarly, pledge of shares would not fall within the concept of guarantee and indemnity so as to bring it within the meaning of financial debt. So if somebody has pledged the shares, so that will not be covered under the definition of financial debt. Similarly, the payment received for shares duly issued to a third party at the request of the payee as evident from official records would not be a debt. There should not be an element of equity. It should be in the nature of a debt. In Challenge Sanghani, it was held that it is manifestly clear that money advanced by a promoter director or a shareholder of the CD as a stakeholder to improve financial health of the company and boost its economic prospects would have the commercial effect of borrowing on the part of the CD, notwithstanding the fact that no provision is made for interest thereon. At times, directors give loan to the company. So, even if a director has given a loan to the company, then also it is in the nature of a financial debt. In real estate projects, money is raised from the allottee against consideration for the time value of money. Thus, allottees are to be regarded as financial creditors. Now, in case of intercorporate deposits, if intercorporate deposit is made for a certain period which was to be paid back with interest, then such transaction will fall in the definition of financial debt. Okay. Now, the amount raised under forward purchase agreement would not come within the definition of financial debt unless it bears the dual attributes of having been disbursed against the consideration for time value of money and has the commercial effect of a borrowing. The definition of financial debt does not expressly exclude an interest-free loan. So it could be with interest, it could be interest-free also. So financial debt would have to be construed to include interest-free loans advanced to finance the business operations of the corporate body. Now let us again go back to our definitions. Now financial position. Financial position in relation to any person means the financial information of a person as on a certain date. Information memorandum means a memorandum prepared by a resolution applicant. Resolution professional, sorry, under subsection 1 of section 29. So this information document, this information memorandum is some sort of a prospectus, say, which is intended to invite new resolution applicants. It gives the snapshot of the company, its assets and liabilities as on a date. Initiation date. Initiation date means the date on which the financial creditor, corporate applicant or operational creditor, the case may be, makes an application to the adjudicating authority for initiating CIRP or PPIRP. So two dates are there. One is initiation date. So that is basically the date of filing of the application. Take it. When he makes the application to the adjudicating authority. And second is the insolvency commencement date. So insolvency commencement date means the date of admission of an application for initiating CIRP by the adjudicating authority under section 7, 9 or 10 as the case may be. So there is a difference between initiation date and insolvency commencement date. Insolvency commencement date means date of admission of application. Initiation date means date of filing of. ठीक है. Then insolvency resolution process costs. In insolvency resolution process cost, what is covered? The amount of any interim finance and the costs incurred in raising such finance. एक बार पढ़िए जरा पूजा जी इंसॉल्वेंसी रेजोल्यूशन प्रोसेस कॉस्ट से.
Insolvency resolution process cost means the amount of any interim finance and the cost incurred in raising such finance, the fees payable to any person acting as a resolution professional. Any cost incurred by the resolution professional in running the business of the CD as a going concern. Any cost incurred at the expense of the government to facilitate the insolvency resolution process. And any other cost as may be specified by the board.
So the first point here is the amount of any interim finance and the cost incurred in raising such finance. As we know, because if a company has come into this stage, that means there is some financial crunch. Now, in order to run it as a going concern, which is the primary objective, because we have seen that it is a beneficial legislation, beneficial for the corporates. It's not a recovery mechanism. So they will try to run the company. And in order to run the company, some finances may be required. So what is the guarantee to those persons who have financed the company? So their amount will be paid first. That is the guarantee. So it says even before any money is paid to financial creditors or even secured creditors, so first of all, these interim finance providers, they will be paid. Not only the amount, but the cost incurred in raising such finance. They have not used the word interest, they have used the word cost. So cost means processing fees plus interest. Second is the fees payable. So any person who is acting as RP, and the definition of RP they have given that it includes an IRP also. So whatever is the fees paid, that is to be paid in priority. सबसे पहले क्या पेमेंट होना है हमारा इंसॉल्वेंसी रेजोल्यूशन प्रोसेस कॉस्ट. ठीक है. इंटरिम फाइनेंस कॉस्ट, फीस पेबल टू आरपी, देन any cost incurred by the RP in running the business of the corporate debtor as a going concern. ठीक है. जो भी डे टू डे रनिंग में इन्वॉल्व है, जो भी कॉस्ट आएगी, वो भी आपको इंसॉल्वेंसी रेजोल्यूशन प्रोसेस कॉस्ट का पार्ट है. देन एनी कॉस्ट इनकर्ड एट द एक्सपेंस ऑफ द गवर्नमेंट टू फैसिलिटेट द इंसॉल्वेंसी रेजोल्यूशन प्रोसेस एंड एनी अदर कॉस्ट एज में बी स्पेसिफाइड बाय द बोर्ड. सो ऑल दीज कॉस्ट नाउ दीज आर गिवन इन रेगुलेशन 31 to 34. एक बार रेगुलेशन 34 to 34 देख लेते हैं क्या है. 31 है आपका इंसॉल्वेंसी रेजोल्यूशन प्रोसेस कॉस्ट. ठीक है. 31 है रेगुलेटरी फीस. 32 है फिर आपका 31 बी है अप्रूवल ऑफ कमेटी. 32 इसेंशियल सप्लाईज की जो कॉस्ट है वो. 33 है कॉस्ट ऑफ IRP और 34 है आपकी रेजोल्यूशन पर्सनल कॉस्ट. तो ये सारी कॉस्ट जो है ये आपको दे हैव टू बी पेड इन प्रायोरिटी. ठीक है. सबसे पहले इनका पेमेंट होगा. Then insolvency resolution process period. ये इंसॉल्वेंसी रेजोल्यूशन प्रोसेस पीरियड क्या है? इट मींस द पीरियड ऑफ 180 days beginning from the insolvency commencement date and ending on 180th day. आप पढ़ लीजिए मैडम, पूजा मैडम एक बार पढ़िए आगे. इंटरिम फाइनेंस.
Interim finance means any financial debt raised by the resolution professional during the insolvency resolution process period or by the corporate debtor during the pre-PPIRP as the case may be, and such other debt as may be notified.
So this is the definition of interim finance. So interim finance is any financial debt which is raised by the RP during insolvency resolution process period or by the corporate debtor. Because in case of PPIRP, the control remains with the corporate debtor. So that is why they have used the word corporate debtor. But in CIRP, the powers of management stand suspended and it is take custody and control is with the RP. So that is why they have used the word RP. In case of normal CIRP and in case of PPIRP, they have used the word corporate debtor. Yes, next.
Liquidation cost means any cost incurred by the liquidator during the period of liquidation subject to such regulations as may be specified by the board.
Right.
Liquidation commencement date means the date on which proceedings for liquidation commence in accordance with Section 33 or Section 59 as the case may be.
Right. So Section 33 is talking of normal liquidation and Section 59 is talking of voluntary liquidation.
Okay.
Yes.
Liquidator means an insolvency professional appointed as a liquidator in
Hmm.
accordance with the provisions of Chapter 3 or Chapter 5 of this part as the case may be.
Yes. Next.
Officer for the purposes of Chapter 6 and Chapter 7 of this part means an officer who is in default as defined in Clause 60 of Section 2 of the Companies Act 2013 or a designated partner as defined in Clause G of Section 2 of LLP Act 2008 as the case may be.
Actually, at times, besides the company, liability or penalty may be leviable on the officer or a person who is in default. So, where we will find the definition of officer in default? We have to go to the Companies Act or LLP Act.
Right.
Yes.
Operational creditor means a person to whom an operational debt is owed and includes any person to whom such debt has been legally assigned or transferred.
Right. Yes.
Operational debt means a claim in respect of the provision of goods or services, including employment, or a debt in respect of the payment of dues arising under any law for the timing in force and payable to the central government, any state government, or any local authority.
Now, if we see the definition of operational debt, so they are not talking of interest here. So they are talking of a claim in respect of provision of goods or services, including employment, or a debt in respect of payment of dues arising under any law, say income tax dues or GST dues, but they are not talking of interest here. Whereas when we read the definition of financial debt, they said it includes
Interest.
debt along with interest. And we have seen case laws also where they say that in case of operational debt, it has to be only the principal amount and not the interest. Yes.
Personal guarantor means an individual who is the surety in a contract of guarantee to a corporate debtor.
Right. So here, personal guarantor, we have seen the definition of corporate guarantor. So corporate guarantor means a corporate person who has given the guarantee, and personal guarantor is an individual who is surety in a contract of guarantee to a corporate debtor. So the question arises if a partnership firm gives the guarantee, then it will be covered under the concept of personal guarantor. Yes.
Personnel includes the directors, managers, key managerial personnel, designated partners, and employees, if any, of the corporate debtor.
So in this IBC, we will find various terms. One term is officer or officer in default. Then we'll find the term this personnel, and then we'll find the term employees and workmen. So these are the various terms because liabilities are attached to these persons in a different manner. So personnel includes the directors, manager, key managerial personnel, designated partners, and employees, if any. So workers are not covered here in the definition of personnel. Yes, please.
Preliminary information memorandum means a memorandum submitted by the corporate debtor under clause B of subsection 1 of section 54G.
Yes. So we have read the definition of information memorandum, which is a document akin to a prospectus. But in case of PPIRP, there is a concept of preliminary information memorandum also, because the board continues to stay in control. The corporate debtor continues to stay in control. So the liability is on the corporate MSME to prepare this preliminary information memorandum. And based on this preliminary information memorandum is prepared by the RP in case of PPI. Yes.
Pre-package insolvency commencement date means the date of admission of an application for initiating the pre-package insolvency resolution process by the adjudicating authority under clause A of subsection 4 of section 54C.
Right. So, like there is a concept of insolvency commencement date, which is applicable in case of normal CIRP. This pre-packaged insolvency commencement date is the date of application in case of pre-packed process. And this pre-packaged insolvency resolution process cost This is also similar to insolvency resolution
Yeah.
process cost.
Sir, is it date of admission or date of application, sir?
Which one?
A prepacked insolvency commencement date.
No. Date of admission of our application. It is
Okay.
clearly date of admission.
Okay. Okay.
Hmm. Right. So prepackaged insolvency resolution process period.
Prepackaged insolvency resolution process period means the period beginning from the prepackaged insolvency commencement date and ending on the date on which an order under subsection 1 of section 54L or subsection 1 of section 54N or subsection 2 of section 54O, as the case may be, is passed by the adjudicating authority.
Unlike CIRP, there could be various fallouts of this prepackaged insolvency resolution process. So when this process ends, a liquidation order may be made. This prepackaged insolvency resolution process may be converted into normal CIRP if other conditions are met, or it may be terminated. So depending upon that, the period, this prepackaged insolvency resolution process period will be determined. About this, we will read in detail when we go to the process of PPIRP. Yes, please.
Related party. In relation to corporate debtor means a director or partner of the corporate debtor or relative of the director or partner of the corporate debtor. A key managerial personnel of the
So
corporate debtor.
first definition is director or partner of the corporate debtor or relative of director or partner of the corporate debtor. This is the first. Now, as we go further down in this 524, the relationships will be extended. First of all, we will be seeing some direct relationships based on the relation or association with the company. And then as we go further down, even employees may be covered. Even a person who is controlling the company may be covered. Even a person on whose advice the company or board of directors are accustomed to act may be covered. So I'll share with you another PPT in which I have compiled the illustrations for this related party. मैं वो एक बार आपको दिखाता हूँ 524 के लिए just give me 1 minute. Just a minute. Yes. This is the fine. Illustrations for related party. So I hope now it is visible on your screen. So what it says? It says that in order to be covered under section 524, The first condition is that there has to be a corporate person on at least one side. If there are non-corporate persons on both sides, then the relationship shall not be covered under section 5 subsection 24. Once we are sure that there is a corporate person on at least one side, we have to ensure that either party is able to control or influence the business decisions, which could be by virtue of relationship, it could be by virtue of shareholding, ownership, control, decision making ability, etc. Now, subclause A, B, and C, if we see, so they contain relatively simpler relationships. So let us see subclauses A, B, and C by way of illustrations. So what A says, 524A, director or partner of the corporate debtor or relative of director or partner of the corporate debtor. तो एक बार पूजा जी समझाइए इसको देखकर. Suppose there is a company XYZ Private Limited. It could be either a company or an LLP. Now, director of XYZ Private Limited is there. So, this director and this company, they are related parties. Director is an individual, but the company is a corporate person. So, it is covered under section 524. इस तरह से समझाइए पूजा जी एक बार. जहां नहीं समझ में आएगा I will intervene. Yes.
Director will be included as a related party in this case. Also, if there is any relative of director,
Yes.
that will
That
also
will
be included in the category of related parties.
Right.
And in case of LLP, the partner of LLP will be covered under a definition of related party. And a relative of a partner of LLP,
He will also be.
he will also be included in the
ये
category.
तो ए वाले में किसी को डाउट तो नहीं है. 524A में सबसे सिंपल है ये. नेक्स्ट देखिए.
A key managerial person of the CD or a relative of KMP of the CD.
Right.
In case of a company, the KMPs will also be included in the category of related parties and their relatives also.
Right.
And in case of LLP, that is also the same. Their KMPs as well as the relatives of KMPs are included in the category of related parties.
ठीक है. सिंपल है तो कोई डाउट नहीं इसमें. चलिए सी. अब
So
यहाँ
one
तो
doubt, sir.
हाँ
So one doubt is, sir.
पूछिए. Yes.
Sir, who are KMPs in LLPs? Like in private limited companies, CS, CFO, and CEO are the
KMP is and LLP is, they are basically designated partners.
Okay. Okay.
Yes. C point.
A LLP or a partnership firm in which a director, partner, or manager of the CD or his relative is a partner.
अब यहां पर क्या आ गया? LLP और पार्टनरशिप फर्म. यहां पर पार्टनरशिप फर्म भी आ गई. ठीक है.
जिसमें किसी कंपनी के डायरेक्टर, पार्टनर ऑफ LLP और मैनेजर ऑफ कॉर्पोरेट डेटर
और हिज रिलेटिव
और हिज रिलेटिव इज अ पार्टनर.
भाई पहले क्या था? पहले कंपनी के साथ रिलेशनशिप. अब क्या है? डायरेक्टर का रिलेशनशिप है. किसके साथ? LLP या पार्टनर. भाई एक कंपनी में एक डायरेक्टर है. ठीक है. अब वो किसी LLP में पार्टनर भी हो सकता है या पार्टनरशिप फर्म में पार्टनर हो सकता है. तो उस केस में क्या होगा? वो कंपनी और वो जो LLP है दोनों रिलेटेड पार्टी माने जाएंगे. मतलब ये है. ठीक है जी. These are all the relationships. चलिए नेक्स्ट देखते हैं. नाउ सब क्लॉज डी एंड डी. डी एंड डी में क्या है? दे कवर केसेस वेयर ए डायरेक्टर अलोंग विद हिज रिलेटिव्स होल्ड्स मोर देन 2% शेयर कैपिटल और पेड अप शेयर कैपिटल. सबसे पहली बात, डायरेक्टर होना जरूरी है. इट इज नेसेसरी टू बी ए डायरेक्टर. डायरेक्टर अलोंग विद शेयर होल्डर्स. और शेयर होल्डिंग कितनी है? मोर देन 2%. एग्जैक्ट 2% कवर्ड नहीं है. और इट कुड बी आइदर शेयर कैपिटल और पेड अप शेयर कैपिटल. तो क्लॉज डी में क्या है? क्लॉज डी सेज ए प्राइवेट कंपनी इन विच ए डायरेक्टर, पार्टनर or manager of the corporate debtor is a director and holds along with his relatives more than 2% of its share capital. ठीक है, तो दिस इज आई हैव एक्सप्लेन्ड बाय वे ऑफ एन एग्जांपल। एक डायरेक्टर है XYZ प्राइवेट लिमिटेड का, ठीक है, ही इज डायरेक्टर इन अनदर कंपनी ऑल्सो, हो सकता है ना, ही इज डायरेक्टर इन ABC प्राइवेट लिमिटेड ऑल्सो एंड होल्ड्स अलॉन्ग विद रिलेटिव्स मोर देन 2% ऑफ शेयर कैपिटल ऑफ ABC प्राइवेट लिमिटेड। तो ये दोनों कंपनी जो है XYZ प्राइवेट लिमिटेड और ABC प्राइवेट लिमिटेड, दे विल बी रिलेटेड पार्टीज। ठीक है, ये मतलब। और ई में क्या है, ए पब्लिक कंपनी इन विच ए डायरेक्टर, पार्टनर और मैनेजर ऑफ द कॉर्पोरेट डेटर इज ए डायरेक्टर एंड होल्ड्स अलोंग विद रिलेटिव्स मोर देन 2% ऑफ इट्स पेड अप शेयर कैपिटल। ठीक है, तो डी और ई सिमिलर है, सिर्फ उसमें एक जगह शेयर कैपिटल लिखता है और एक जगह पेड अप शेयर कैपिटल लिखता है। इन केस ऑफ पब्लिक कंपनी दे हैव यूज्ड द वर्ड पेड अप शेयर कैपिटल, इन केस ऑफ प्राइवेट कंपनी दे हैव यूज्ड द वर्ड शेयर कैपिटल। अच्छा, एफ क्लॉज क्या कहती है, एनी बॉडी कॉर्पोरेट, यहां पर पहली बार हमने बॉडी कॉर्पोरेट वर्ड यूज किया, तो एनी बॉडी कॉर्पोरेट हुज बोर्ड ऑफ डायरेक्टर्स, मैनेजिंग डायरेक्टर और मैनेजर इन द ऑर्डिनरी कोर्स ऑफ बिजनेस एक्ट्स ऑन द एडवाइस, डायरेक्शंस और इंस्ट्रक्शंस ऑफ ए डायरेक्टर, पार्टनर और मैनेजर ऑफ द कॉर्पोरेट डेटा। ठीक है, तो क्लॉज एफ में क्या हो रहा है, इट यूजेस द वर्ड बॉडी कॉर्पोरेट फॉर द फर्स्ट टाइम। अब बॉडी कॉर्पोरेट में क्या होगा, बॉडी कॉर्पोरेट इंक्लूड्स ए कंपनी इनकॉर्पोरेटेड आउटसाइड इंडिया आल्सो, है ना। अब यहां पर कोई कॉमन डायरेक्टर नहीं है, देखो, ठीक है, पार्टनर भी नहीं है, ना ही कोई शेयर होल्डिंग है, लेकिन रिमोट कंट्रोल है। क्या कहता है वो, एक्ट्स इन द ऑर्डिनरी कोर्स ऑफ बिजनेस। Another important thing to note is acting in the ordinary course of business and not under any special circumstances or in a professional capacity. So here it could be difficult for the RP to prove such a connection. It could be on the basis of press reports. जैसे एक इंडियन कंपनी है और एक बाहर की कंपनी है, दोनों जॉइंट प्रेस कॉन्फ्रेंस कर रहे हैं कि भाई वी विल बी एक्सिक्यूटिंग दिस प्रोजेक्ट, इसका मतलब वो रिलेटेड पार्टीज। ठीक है, कोई बोर्ड ऑफ डायरेक्टर्स की रिपोर्ट में कुछ रेफरेंस हो सकता है या कुछ कंक्रीट एविडेंस। ठीक है, क्लॉज जी, एनी LLP और पार्टनरशिप फर्म हुज पार्टनर्स और एम्प्लॉइज, अब यहां पर एम्प्लॉय भी आ गया, अभी तक एम्प्लॉय वर्ड नहीं आया था, यहां एम्प्लॉय भी आ गया, और एम्प्लॉयज इन द ऑर्डिनरी कोर्स ऑफ बिजनेस एक्ट्स ऑन द एडवाइस, डायरेक्शंस और इंस्ट्रक्शंस ऑफ ए डायरेक्टर, पार्टनर और मैनेजर ऑफ द कॉर्पोरेट डेटा। So in subclause G, the word employee has been used for the first time. Another important thing is in the ordinary course of business. ठीक है, such a relationship would not be easy to establish, but an inference could be drawn from the premises in which the business is being run, frequency of interaction, signature on documents. कई बार क्या होता है, एक ही प्रीमिसेस से एक से ज्यादा कंपनीज चल रही होती है ना, कंपनी भी वहां चल रही है, LLP भी चल रही है, पार्टनरशिप फर्म भी चल रही है ना, वाउचर पर एक ही आदमी साइन कर रहा है, तो ये इस केस में क्या होगा, ये रिलेटेड पार्टीज। एच बोलता है एनी पर्सन ऑन हुज एडवाइस, डायरेक्शंस और इंस्ट्रक्शंस ए डायरेक्टर, पार्टनर और मैनेजर ऑफ द कॉर्पोरेट डेटर इज अकस्टम्ड टू। अब यहां वर्ड लिखा एनी पर्सन, तो पर्सन की डेफिनेशन में क्या है, पर्सन में इंक्लूड इंडिविजुअल्स, HUF, ट्रस्ट एटसेट्रा एज वेल। पर्सन की भी डेफिनेशन दे रखी है ना। द टर्म अकस्टम्ड टू एक्ट ऑल्दो नॉट डिफाइंड इन IBC, कस्टम टू एक्ट डिफाइंड नहीं है IBC में, है ना, और कंपनीज एक्ट में भी नहीं है, बट इट सजेस्ट्स हैबिचुअल टेंडेंसी टू फॉलो एंड ओबे द एडवाइस, इंस्ट्रक्शंस एंड डायरेक्शंस ऑन अ रेपिटेटिव बेसिस। ठीक है, जैसे कंपनी है, मान लीजिए वो कंपनी ट्रस्ट के एडवाइस पर काम करती है, तो वो कंपनी और वो ट्रस्ट जो है वो क्या है, रिलेटेड पार्टी। आई क्या है, ए बॉडी कॉर्पोरेट विच इज ए होल्डिंग सब्सिडरी और एन एसोसिएट कंपनी। तो इसमें तो डायरेक्ट रिलेशनशिप है, अगर एक कंपनी होल्डिंग और सब्सिडरी है तो वो रिलेटेड पार्टी हो गई, सब्सिडरी होल्डिंग है तो हो गई, एसोसिएट कंपनी है तो भी हो गई। और ए सब्सिडरी ऑफ ए होल्डिंग कंपनी टू विच द कॉर्पोरेट डेटर इज ए सब्सिडरी, मतलब दोनों ही एक कंपनी के सब्सिडरी, को सब्सिडरी की कॉन्सेप्ट, तो उस केस में क्या होगा, ये जो है रिलेटेड पार्टी हो जाएगी। ठीक है, here the body corporate is a holding subsidiary or an associate of the CD, or both the body corporate and the corporate director are subsidiaries of a holding company. तो क्या क्या कवर हो जाएंगे? होल्डिंग कंपनी ऑफ सीडी, सब्सिडरी कंपनी ऑफ सीडी, एसोसिएट कंपनी, को सब्सिडरी. क्या चेक करना है आपको? कंट्रोलिंग द कंपोजिशन ऑफ बोर्ड ऑफ डायरेक्टर्स. ठीक है. नाउ हाउ कैन यू कंट्रोल द कंपोजिशन ऑफ बोर्ड ऑफ डायरेक्टर्स? व्हेन यू हैव द पावर टू अपॉइंट और रिमूव ऑल और मेजॉरिटी ऑफ द डायरेक्टर्स. ठीक है. और मोर देन 50% शेयर कैपिटल ऑन इट्स ओन और अलॉन्ग विद इट्स सब्सिडरीज. ठीक है. और एबिलिटी टू इन्फ्लुएंस डिसीजन मेकिंग होल्डिंग एटलीस्ट 20% ऑफ शेयर कैपिटल. तो यहाँ 20% में एसोसिएट बन जाता है, और अगर मोर देन 50% होगा तो फिर होल्डिंग सब्सिडरी का रिलेशनशिप. नेक्स्ट है जे, एनी पर्सन हु कंट्रोल्स मोर देन 20% ऑफ वोटिंग राइट्स इन द कॉर्पोरेट डेटार ऑन अकाउंट ऑफ ओनरशिप और वोटिंग एग्रीमेंट. अब ये जो क्लॉजेस हैं जे और के, ये दोनों सिमिलर हैं. जे में क्या हो रहा है? एनी पर्सन इज कंट्रोलिंग, और के में क्या हो रहा है? सी डी इज कंट्रोलिंग. ठीक है. नाउ हु इज कंट्रोलिंग? एनी पर्सन. एनी पर्सन में इंडिविजुअल, पार्टनरशिप, फॉर्म, ट्रस्ट, कुछ भी हो सकता है. एंड कंट्रोल कुड बी डायरेक्ट और इनडायरेक्ट. और कंट्रोल क्या करना है? वोटिंग राइट्स. वोटिंग राइट क्या है? राइट ऑफ ए मेंबर ऑफ ए कंपनी टू वोट इन एनी मीटिंग और बाई पोस्टल बैलेट. कितना कंट्रोल करना है? मोर देन 20%. एंड हाउ इट इज टू बी कंट्रोल्ड? ऑन अकाउंट ऑफ ओनरशिप और ए वोटिंग अरे एग्रीमेंट. इसका एग्जांपल लेंगे. एनी पर्सन हु कंट्रोल्स, सपोज देयर इज ए एचयूएफ. ठीक है. एचयूएफ में देयर आर 4 को पास्टर्स. अब उनके पास इंडिविजुअली 6% है शेयर्स. ठीक है. वो कर्ता को ऑथराइज कर देते हैं कि भाई यू हैव टू वोट इन ए पर्टिकुलर फैशन. तो 6 into 4 24% हो गया, मोर देन 20% हो गया, है ना. तो दिस पर्सन, दिस एचयूएफ इज कंट्रोलिंग मोर देन 20% ऑन अकाउंट ऑफ ओनरशिप और वोटिंग राइट. तो ये एचयूएफ और ये जो कंपनी है ये रिलेटेड पार्टीज हो. ठीक है. क्लॉज के क्या है? एनी पर्सन इन हुम द कॉर्पोरेट डेटर कंट्रोल्स मोर देन 20%. अब सीडी कंट्रोल कर रहा है उस पर्सन के अंदर. ठीक है. ऑफ द वोटिंग राइट्स ऑन अकाउंट ऑफ ओनरशिप और वोटिंग एग्रीमेंट. तो हु इज कंट्रोलिंग? सीडी. ठीक है. कंट्रोल कुड बी डायरेक्ट और इनडायरेक्ट. व्हाट इज टू बी कंट्रोल्ड? वोटिंग राइट्स. Who could be controlled? Anyone whose decisions are taken, where decisions are taken by way of voting. How much is to be controlled? More than 20%. And how it is to be controlled? On account of ownership or voting agreement. L क्या है? Any person who can control the composition of board of directors or corresponding governing body of the corporate debtor. Word क्या लिखा? Who can control. Can control लिखा. So the stress is on the ability to control. ठीक है. यूज ऑफ द वर्ड कैन. एक्चुअली सच एबिलिटी मे और मे नॉट बी एक्सरसाइज. नाउ हु इज कंट्रोलिंग? एनी पर्सन. व्हाट इज बीइंग कंट्रोल्ड? कंपोजिशन ऑफ द बोर्ड ऑफ डायरेक्टर्स और कॉरस्पॉन्डिंग गवर्निंग बॉडी ऑफ द सीडी. ठीक है. एंड हाउ कंपोजिशन ऑफ बोर्ड ऑफ डायरेक्टर्स कुड बी कंट्रोल्ड? व्हेन one has the ability to appoint or remove the majority of the directors. And what is the difference between board of directors and governing body? In case of company, it is board of directors. And if it is a body corporate other than a company, it is the governing body. ठीक है. Stress is on the ability to control. Use of the word can. Actually, such ability may or may not be exercised. Then M. Any person who is associated with the corporate debtor on account of participation in policy making processes of the corporate debtor. Participation है. Suppose a person is a member of a policy making committee. तो क्या हो जाएगा? वो
Related parties.
related party. Having more than 2 directors in common between the corporate debtor and such person. अगर 2 से ज्यादा डायरेक्टर कॉमन है तो भी क्या हो जाएगा? रिलेटेड. इंटरचेंज ऑफ मैनेजरियल पर्सनल बिटवीन द कॉर्पोरेट डेटर एंड सच पर्सन. आप मेरी कंपनी में मैनेजर बन जाओ, मैं आपकी कंपनी में, ये होता है इंटरचेंज. तो उस केस में भी रिलेटेड पार्टी. प्रोविजन ऑफ एसेंशियल टेक्निकल इंफॉर्मेशन टू और फ्रॉम द कॉर्पोरेट डेटर. कोई ट्रांसफर ऑफ टेक्नोलॉजी एग्रीमेंट है ना. तो उस केस में भी क्या होगा? रिलेटेड पार्टी हो जाएगी. ठीक है. ये इलस्ट्रेशंस दे रखी हैं इसकी. दिस यू कैन गो थ्रू. तो इस तरह से हमने इलस्ट्रेशन के थ्रू समझाने की कोशिश की है कि भाई ये होती क्या है रिलेटेड पार्टी की कॉन्सेप्ट. ठीक है. ये मैं आपके साथ शेयर कर दूं. ये भी हो गया हमारा। अच्छा। ये मैं यहाँ पर भी चैट बॉक्स में भी शेयर कर देता हूँ, यहाँ से भी आ जाएगा। हो गया जी शेयर, है ना? इलस्ट्रेशन फॉर रिलेटेड पार्टी। तो 520। अब आगे चलते हैं हम लोग। ये 524 हमारा पूरा हो गया। अब चलते हैं 524A। 524A क्या है? रिलेटेड पार्टी इन रिलेशन टू एन इंडिविजुअल। तो 524 पे तो था रिलेटेड पार्टी इन रिलेशन टू ए कॉर्पोरेट डेटा, और यहां पर है रिलेटेड पार्टी इन रिलेशन टू एन इंडिविजुअल। तो रिलेटेड पार्टी इन रिलेशन टू एन, अब आप कहोगे कि जी रिलेटेड पार्टी इन रिलेशन टू इंडिविजुअल पढ़ने की क्या जरूरत है, क्योंकि हमें पार्ट 3 में ये काम आएगा। ये डेफिनेशन यहीं पर दे दी, और पार्ट 3 में भी व्हेन वी विल सी द कॉन्सेप्ट ऑफ रिलेटेड पार्टी, तो वहां पर इसका रेफरेंस देता है 524A का। ठीक है। तो रिलेटेड पार्टी इन रिलेशन टू एन इंडिविजुअल मीन्स ए पर्सन हु इज ए रिलेटिव ऑफ द इंडिविजुअल और ए रिलेटिव ऑफ द स्पाउस ऑफ द इंडिविजुअल। ठीक है। आपका रिलेटिव हो या आपकी स्पाउस का रिलेटिव हो, तो दोनों केसेस में ये जो है रिलेटेड पार्टी आ जाएगा। ठीक है। पार्टनर ऑफ एलएलपी और एल इस पर ना हमने एक वो बना रखा है, इसका एक चार्ट। वो चार्ट भी मैं आपके साथ शेयर कर दूं। ठीक है। उस चार्ट से आपको पूरा रिलेटेड पार्टी का कॉन्सेप्ट समझ में आ जाएगा इन रिलेशन टू एन इंडिविजुअल। पार्टनर ऑफ एलएलपी और एलएलपी और पार्टनरशिप फॉर्म इन विच द इंडिविजुअल इज ए पार्टनर। ठीक है। ए पर्सन हु इज ए ट्रस्टी ऑफ द ट्रस्ट इन विच द बेनिफिशियरीज ऑफ द ट्रस्ट इंक्लूड द इंडिविजुअल और द टर्म्स ऑफ द ट्रस्ट कन्फर ए पावर ऑन द ट्रस्टी विच में बी एक्सरसाइज्ड फॉर द बेनिफिट ऑफ द इंडिविजुअल। ठीक है। तो उस केस में क्या होगा, वो इंडिविजुअल और वो जो ट्रस्ट है वो दोनों रिलेटेड पार्टी हो जाएंगे। A private company in which the individual is a director and holds along with his relatives more than 2% of its share capital. ठीक है। A public company in which the individual is a director and holds along with the relatives more than 2% of its paid up share capital. A body corporate whose board of directors, managing director or manager in the ordinary course of business acts on the advice, directions or instructions of the individual. LLP or partnership firm whose partners or employees in the ordinary course of business acts on the advice, directions or instructions of the individual. A person on whose advice, directions or instructions the individual is accustomed to act. A company where the individual or the individual along with this related party owns more than 50% of the share capital of the company or controls the appointment of the board of directors of the company. ठीक है। For the purpose of this clause, relative with reference to any person means anyone who is related to another in the following manner, namely members of HUF। तो members of HUF जो है आपस में रिलेटिव है। ठीक है। देन हस्बैंड, वाइफ, फादर, मदर, सन, डॉटर, सन्स डॉटर एंड सन, डॉटर्स डॉटर एंड सन, ग्रैंड सन्स डॉटर एंड सन, ग्रैंड डॉटर्स डॉटर एंड सन, ब्रदर, सिस्टर, brother's son and daughter, sister's son and daughter, father's father and mother, mother's father and mother, father's brother and sister, mother's brother and sister. ठीक है। And wherever the relation is that of a son, daughter, sister or brother, their spouses shall also be included. तो मैं एक चार्ट शेयर कर दूंगा आपसे, उस चार्ट में ये सारे जितने भी रिलेशंस हैं इनको डिस्क्राइब किया गया। ठीक है। Now, resolution applicant. Resolution applicant means a person who individually or jointly with any other person submits a resolution plan to the resolution professional pursuant to the invitation made under clause H of subsection 2 of section 25 और pursuant to section 54 की। ठीक है। क्योंकि रेजोल्यूशन एप्लीकेंट क्या होगा, नॉर्मल CIRP में भी हो सकता है और PPIRP में भी हो सकता है। तो ये दोनों सेक्शन वहां के, एक जो 25(2)H है ये CIRP का सेक्शन है, और सेक्शन 54 ये PPIRP का सेक्शन। ठीक है। रेजोल्यूशन प्लान मीन्स ए प्लान प्रपोज्ड बाय द रेजोल्यूशन एप्लीकेंट for insolvency resolution of the corporate debtor as a going concern. ठीक है. And for the removal of doubts, it is hereby clarified that a resolution plan may include provision for the restructuring of the corporate debtor, including by way of merger. ठीक. Amalgamation and demerger. Then resolution professional. A resolution professional for the purpose of this part means an insolvency professional appointed to conduct the CIRP or PPIRP and includes an interim resolution professional. ठीक है. Voting share क्या है? Voting share means the share of the voting right of a single financial creditor in the committee of creditors, which is based on the proportion of the financial debt owed to such a financial creditor in relation to the financial debt owed by the corporate debtor. क्योंकि यहां पर जो भी कॉन्सेप्ट है ना, सब पे क्या होता है, जैसे ही क्लेम एक्सेप्ट होता है वोटिंग शेयर असाइन कर देता है आईआरपी उसको. ठीक है. तो वोटिंग शेयर क्या है? वोटिंग शेयर मीन द शेयर ऑफ द वोटिंग राइट ऑफ ए सिंगल फाइनेंशियल क्रेडिटर इन द कमिटी ऑफ क्रेडिटर्स विच इज बेस्ड ऑन द प्रोपोर्शन ऑफ द फाइनेंशियल डेट owed to such financial creditor in relation to the financial debt owed by the corporate debtor. जैसे सपोज टोटल फाइनेंशियल डेट आपका 400 करोड़ का है. ठीक है. एक फाइनेंशियल क्रेडिटर है जिसका डेट 100 करोड़ का है, तो उसके पास 25% शेयर आ जाएगा इस तरह से. ठीक है. नाउ चैप्टर 2 CIRP सेक्शन 6 पर्सन्स हु मे इनिशिएट CIRP. कौन कौन इनिशिएट कर सकते हैं? वेयर एनी कॉर्पोरेट डेटर कमिट्स ए डिफॉल्ट. ठीक है. सबसे पहले ट्रिगर पॉइंट क्या है? डिफॉल्ट होना चाहिए. अगर डिफॉल्ट नहीं है तो आप इनिशिएट नहीं कर सकते प्रोसेस. ठीक है. ए फाइनेंशियल क्रेडिटर, एन ऑपरेशनल क्रेडिटर और द कॉर्पोरेट डेटर इटसेल्फ. फाइनेंशियल क्रेडिटर कौन है? जिसने लोन दिया है. ऑपरेशनल क्रेडिटर कौन है? जिसने गुड्स या सर्विसेज सप्लाई की है, या एम्प्लॉय है, या गवर्नमेंट डिपार्टमेंट है ना. और द कॉर्पोरेट डेटर इटसेल्फ मे इनिशिएट CIRP in respect of such corporate debtor in the manner as provided under this chapter. ठीक है. सेक्शन 7 बोलता है इनिशिएशन ऑफ कॉर्पोरेट इंसॉल्वेंसी रेजोल्यूशन प्रोसेस बाय फाइनेंशियल क्रेडिटर. तो फाइनेंशियल क्रेडिटर कैसे इनिशिएट कर सकता है? अब देखिए, सबसे पहले बिफोर वी टेक अप दिस सेक्शन हमें क्या अंडरस्टैंड करना है कि व्हाट कुड बी द वेरियस टाइप्स ऑफ फाइनेंशियल क्रेडिटर्स. देयर कुड बी ए सिंगल फाइनेंशियल क्रेडिटर. ठीक है. एक बैंक ने लोन दिया हुआ है, तो बैंक जो है, बैंक कुड बी ए फाइनेंशियल क्रेडिटर. होम बायर्स हो सकते हैं फाइनेंशियल क्रेडिटर. वी हैव सीन 5(8)(f) में कि होम बायर्स आर आल्सो कंसिडर्ड अंडर द कॉन्सेप्ट ऑफ फाइनेंशियल क्रेडिटर्स. सिंगली या जॉइंटली भी आप एप्लीकेशन लगा सकते हो. तो सेक्शन 7(1) क्या बोलता है? यस प्लीज पढ़िए जरा पूजा जी. सेक्शन 7 सब सेक्शन 1.
A financial creditor, either by itself or jointly with other financial creditors or any other person on behalf of the financial creditor, as may be notified by the central government, may file an application for initiating CIRP against a corporate debtor before the adjudicating authority when a default has occurred.
तो अभी क्या
Provided
कहता है? ये कहता है इसमें कि फाइनेंशियल क्रेडिटर आइदर बाय इटसेल्फ और जॉइंटली विद अदर फाइनेंशियल क्रेडिटर्स. तो सिंगली भी लगा सकता है और जॉइंटली भी एप्लीकेशन लगा सकता है. यस प्लीज.
provided that for the financial creditors referred to in clauses A and B of subsections 6A of section 21, an application for initiation of CIRP against the corporate debtor shall be filed jointly by not less than 100 of such creditors in the same class or not less than 10% of the total number of such creditors in the same class, whichever is less.
अब सेक्शन 21 में 6A में क्या दिया हुआ है? सेक्शन 21 6A बात करता है कि देयर कुड बी ए केस वेयर, जैसे डिपॉजिट होल्डर्स है. ठीक है. एक बैंक ने डिपॉजिट ले रखे हैं. अब आप प्लीज ट्राई टू अंडरस्टैंड, पहले तो ये लिमिट 1 लाख की थी, है ना. अब एक सिंगल डिपॉजिट होल्डर भी हो सकता है जिसका 1 लाख से ज्यादा डिपॉजिट हो. तो क्या वो एप्लीकेशन लगा पाएगा? द आंसर इज नो. उसके लिए इन्होंने मिनिमम कंडीशन लगाई. कितने होने चाहिए? नॉट लेस देन 100 ऑफ सच क्रेडिटर्स इन द सेम क्लास और नॉट लेस देन 10% ऑफ द टोटल नंबर ऑफ सच क्रेडिटर्स इन द सेम क्लास, विच एवर इज लेस. जैसे IBC आया तो आईबीसी आने के बाद क्या होता था, एक सिंगल होम बायर भी एप्लीकेशन लगा सकता था। तो बिल्डर्स को बड़ी परेशानी हो गई। बिल्डर ने कहा भाई देखो ऐसा है, प्रोजेक्ट बिल्कुल सही चल रहा है, एक आदमी को दिक्कत है, तो एक आदमी की वजह से थोड़ी सीआईआरपी शुरू हो जाएगी। तो इन्होंने ये कंडीशन लगा दी यहां पर। ये कंडीशन बाद में आई थी। ये आया था आपका 2000, ये जो आया आपका, ये आया था आपका 29 में, 2019 में। तो 2019 में ये अमेंडमेंट आई थी, क्योंकि प्रॉब्लम आ रही थी भाई। तब तक तो 1,000 की, 1 लाख के रुपए की लिमिट थी। 1 लाख रुपए तो किसी के भी हो सकते हैं। तो उन्होंने कह दिया भाई अगर कोई होम बायर्स है जैसे, या फिर डिपॉजिट होल्डर्स है, या डिबेंचर होल्डर्स है, तो उसमें कितने लोग मिनिमम एक रहेगा इसमें, या तो 100 हो कम से कम, या फिर नॉट लेस देन 10% ऑफ द टोटल नंबर ऑफ सच क्रेडिटर्स इन द सेम क्लास। यस प्लीज, सेकंड प्रोवाइजो।
Provided further that for financial creditors who are allottees under a real estate project, an application for initiating CIRP against the corporate debtor shall be filed jointly by not less than 100 of such allottees under the same real estate project, or not less than 10% of the total number of such allottees under the same real estate project, whichever is less.
हाँ, अब क्या हो गया, जैसे अलॉटीज है भाई, एक बिल्डर है, एक बिल्डर तो जगह जगह प्रोजेक्ट बनाता है। तो अब ये जो 100 वाली लिमिट है, या जो 10% की लिमिट है, ये एक प्रोजेक्ट वाइज देखी जाएगी। क्यों प्रोजेक्ट वाइज देखी जाएगी? क्योंकि क्या होता है, जनरली एसेट्स भी प्रोजेक्ट वाइज होते हैं, और फंडिंग भी, लायबिलिटीज भी प्रोजेक्ट वाइज होती हैं। तो उसने कहा भाई जिस प्रोजेक्ट में प्रॉब्लम है, उसी प्रोजेक्ट के कम से कम 100 लोग होने चाहिए, या फिर 10% होना चाहिए ऑफ द टोटल नंबर ऑफ सच अलॉटीज अंडर द सेम रियल एस्टेट प्रोजेक्ट, तभी एप्लीकेशन लगा सकते हैं। ठीक है, चलिए।
Provided also that where an application for initiating CRP against a corporate debtor has been filed by a financial creditor referred to in the first and second provisos and has not been admitted by the adjudicating authority before the commencement of the IBC Amendment Act 2020, such applications shall be modified to comply with the requirements of the first or second proviso within 30 days of the commencement of the said act, failing which the application shall be deemed to be withdrawn before its admission.
अब इसमें क्या आया, जैसे मैंने बताया ये बीच में अमेंडमेंट आ गई थी 2019 में। अब क्वेश्चन ये उठा कि जो पहले एप्लीकेशन लगा रखी उनका क्या होगा। भाई पहले तो सिंगल फाइनेंशियल क्रेडिटर ने एप्लीकेशन लगा रखी थी, मान लो सिंगल होम बायर ने। अब ये कहने लगे भाई कम से कम 100 होने चाहिए, या 10% होने चाहिए। तो जो पहले एप्लीकेशन लगाए उनका क्या होगा? उनको कह दिया भाई उनको भी मॉडिफाई करना पड़ेगा। अगर मॉडिफाई नहीं करोगे तो ये विड्रॉन मान ली जाएगी। ठीक है, इस पर फिर केस लॉ भी आए कि भाई ऐसे कैसे कर सकते हो, और हम कहाँ से ढूंढ के लाएंगे। भाई एक होम बायर है, वो कह रहा है आप 100 ढूंढ के लाओ, अब मैं 100 कहाँ से ढूंढूंगा जी, है ना। यस, एक्सप्लेनेशन।
Explanation. For the purposes of this subsection, a default includes a default in respect of a financial debt owed not only to the applicant financial creditor, but to any other financial creditor of the corporate debtor.
हाँ, यस।
The financial creditor shall make an application under subsection 1 in such form and manner and accompanied with such fees as may be prescribed.
हाँ,
Rule
तो
4.
अब इसमें ये है कि भाई ये जो एप्लीकेशन लगेगी ये कौन से फॉर्म में लगेगी। तो फॉर्म वगैरह आपको कहाँ रूल 4 में दे रखा है, और रूल 4 रूल 8 और 10 आपको पढ़ लेने हैं। तो एक बार रूल 4 रूल 8 और रूल 10 भी पढ़ लेते हैं इसके। रूल 4 क्या कहता है? रूल 4 ये कहता है, रूल कहता है कि फाइनेंशियल क्रेडिटर एप्लीकेशन कौन से फॉर्म में लगाएगा, फॉर्म 1 के अंदर। ठीक है जी, तो फॉर्म 1 में एप्लीकेशन लगेगी, और अगर इफ इट इज एन असाइनी और ट्रांसफरी, तो आपको कॉपी ऑफ असाइनमेंट और ट्रांसफर एग्रीमेंट भी लगाना है। और इस एप्लीकेशन की कॉपी शेल सर्व कॉपी ऑफ द एप्लीकेशन टू द रजिस्टर्ड ऑफिस ऑफ द कॉर्पोरेट डेटार एंड टू द बोर्ड। ठीक है, तो रजिस्टर्ड ऑफिस पर भी इसकी कॉपी भेजनी पड़ेगी, और बोर्ड को भी। और कैसे भेजनी है? बाय रजिस्टर्ड पोस्ट और स्पीड पोस्ट, और बाय हैंड, और बाय इलेक्ट्रॉनिक मीन्स। ठीक है, and in case the application is made jointly, then they may nominate one amongst them to act on their behalf. ठीक है, तो फॉर्म 4 था, रूल 4 था, रूल उसके बाद में 8 है।
8 and 10.
रूल 8 क्या कहता है? विड्रॉल ऑफ एप्लीकेशन, तो एप्लीकेशन में भी विड्रॉन, ठीक है, एडजुडिकेटिंग अथॉरिटी में परमिट। और रूल 10 क्या बोलता है? रूल 10 बोलता है फाइलिंग ऑफ एप्लीकेशन एंड एप्लीकेशन फीस। तो फीस कैसे होगी? फीस के बारे में इन्होंने दे रखा है कि भाई ये आपको शेड्यूल के अंदर दे दिया जाएगा, ठीक है। तो ये शेड्यूल है इसका फीस का, लास्ट में दे रखा है इन्होंने, ये है शेड्यूल ऑफ फीस। तो एप्लीकेशन बाय फाइनेंशियल क्रेडिटर 25,000 रुपए है, एप्लीकेशन बाय ऑपरेशनल क्रेडिटर 2,000 है, एप्लीकेशन बाय कॉर्पोरेट डेटर 25,000, ठीक है। तो ये हमने सेक्शन 7 तक आज कवर कर लिया, बाकी फिर नेक्स्ट क्लास में कवर करेंगे, ठीक है जी। तो इसमें यह है कि आपका कोई क्वेश्चन हो तो पहले पूछ सकते हैं। दूसरा ये कि